we need to raise money and pay kini because àti ń late nsìn tó bá dẹ̀ ti ń di 30 days báyìí ó máa wọnú credit gbogbo àwa mẹ́rẹ̀ẹ̀rin ni. Yeah, àti ń late kò gbọ́dọ̀ tó 30 days tó bá ti lè tó 30 days ó máa wọ record ni. So we have to find a way to raise money. Hello. Good afternoon once again. This is Dr. Olu Asekun here. Welcome to my live podcast. I've been away for a couple of weeks now. It was for a good cause. It was to dedicate a law resource center that my wife and I built for my alma mater. So, I'm back. Today we'll be discussing motion to reopen at the Immigration Court. Motion to reopen at the Immigration Court. I'm going to give some background and I will want you to start sending in your questions as we start. Motion to reopen at the Immigration Court. Okay. So, again, I apologize for my absence in the last couple of weeks. Um, it was for a good cause. So we are back today to continue where we stopped, and that is to continue with the motion to reopen at the Immigration Court. Motion to reopen at EOIR. Now, I know that this topic was briefly discussed while I was away, but I also wanted to repeat it so that I can give it a more comprehensive approach. So, motion to reopen at Immigration Court. It's a little technical. There are so many rules and regulations affecting it. There are procedural issues that we also need to know. So that is why it is important that I repeat this topic, motion to reopen at the Immigration Court. Now, if you have questions, you can start sending them in while we continue with the podcast. Now, talking about motion to reopen at the Immigration Court, if you have a case that you want to reopen, there are different rules governing it. Number one, at the Immigration Court level, you can file a motion to reopen within 90 days. 90 days. This is different from motion to reopen with USCIS, it's different from other motion to reopen, like in absentia order and all that. I believe we have discussed that. But talking about motion to reopen at the Immigration Court, you can file a motion to reopen within 90 days. Once 90 days expire, you can no longer file a motion to reopen, except it falls under one of the exceptions. We will go over the exceptions, but the law is that you can file a motion to reopen within 90 days. Now, motion to reopen is different from motion to reconsider. They are not the same thing, because statutorily, when you are filing a motion to reopen, you have to file it within 30 days at the immigration. If you are filing a motion to reopen, you have to file it within 90 days. However, if you are filing a motion to reconsider, you have to file it within 30 days. A motion to reopen, if you are filing a motion to reopen, you must support it with an affidavit, and you must also provide a new evidence, something that was not available at the prior trial. You cannot just file a motion to reopen for filing's sake. So you have to be able to submit something as evidence why the court should reopen it. That is something that the court didn't consider before, something they didn't have. As I said, it is different from motion to reconsider. When you are talking about motion to reconsider, that one does not require an affidavit. You are saying that the court erred or the court was wrong as a matter of law. So you have to, motion to reconsider is a legal argument. So you have to present a brief to support your motion. So you have to cite statute, authorities, legal authorities, cases, and why you believe the court was wrong, why the court will have to reconsider its decision. So that has to be done within 30 days. That is different from a motion to reopen. For a motion to reopen, that one can be done within 90 days, but you must also attach evidence of what is new in the case. That is something that was not presented previously in the previous trial. So it has to be supported by an affidavit and supported by new evidence or why you believe that the court should reopen the case. Of course, you have to bring up new thing that was not previously available and considered. In addition, talking about motion to reopen before the Immigration Court, this is very critical. A motion to reopen can only be filed once. So it is a one-chance situation. You cannot file multiple motions to reopen at the immigration court. So you can only file motion to reopen one time. And that is why it is very, very important that you file it appropriately and not allow some technicalities or file an incomplete application, because you have only one chance. So once you file it and it is denied, that is it. You cannot go back to refile it. So the only exception, there are two exceptions to the one chance filing of a motion to reopen. One, if it's a decision that was entered in absentia, the one-time rule does not affect it. Secondly, if it's a decision that is, if the motion to reopen is a joint motion that is between the respondent and the government attorneys, the ICE attorneys, if both agree to file the motion, then it will constitute an exception to the one chance motion to reopen. And of course, sua sponte motion is also there. That will also be an exception to the one-time motion to reopen. Sua sponte means that the court on its own, without anybody prompting the court can on its own reopen a case. So that is sua sponte. So the court on its own can reopen a case. So that is also an exception to the one-time motion to reopen. But apart from that, motion to reopen is something that can only be filed one time. You cannot file it multiple times. Secondly, it has to be supported by an affidavit and has to be supported by something that is different. So if a case has gone through trial and was denied, you cannot just file a motion to reopen and represent the same case. If you disagree with the decision, the only thing you can do is to file an appeal. So you cannot file a motion to reopen. However, if there are documents or evidence that you believe that will have affected the court decision, if those documents have been presented to the court or if those evidence have been presented to the court, so you can file a motion to reopen in order to give you an opportunity to present those documents to court. However, most judges will only reopen it if you can show that you didn't have those documents during the prior trial. In other words, if those documents were available at the previous trial, but you choose not to present it, then you cannot go back and file a motion to reopen using the same exact document. The court will not reopen the case on that basis. It has to be documents that were or evidence that were unavailable during the previous trial. Maybe you are trying to get some document from your home country and you have tried everything possible. You are waiting for the document. The document arrived after the trial. Then that is something that the court will consider. Or maybe it is a new evidence that was previously unavailable, that you didn't even know about it. It was something new that just came up. Of course, the court will consider all of that. So that is why motion to reopen is different from motion to reconsider. For motion to reconsider, you don't need any of this evidence. All you need to do is to submit a brief and argue why you believe that the court decision was wrong and why you believe that the court should reconsider its position, its ruling in view of legal authorities. So you write a brief and you attach your brief to your motion to reopen. Again, when we are talking about motion to reopen with EOIR, Executive Office of Immigration Review, that covers immigration court as well as the Board of Immigration Appeal. So it is the same rule. So even though it is under different regulation, they are controlled under different regulation, but even at the Board of Immigration Appeal level, excuse me, motion to reopen can only be filed one time too. It is a one chance situation. So whether you are the immigration court or you are the Board of Immigration Appeal level, once a decision has been reached in your case, if you want to file a motion to reopen, you can only file the motion to reopen one time. One time. And if you are going to file the motion to reopen at the immigration court, you have up to 90 days to file the motion to reopen, up to 90 days. But if you are filing the motion to reopen at the Board of Immigration Appeal, you have 30 days to file the motion to reopen at the Board of Immigration Appeal. Now, if you are filing a motion to reconsider at the immigration court, you have 30 days to file the motion to reconsider at the immigration court. You also have 30 days to file the motion to reconsider at the Board of Immigration Appeal. So the rules are different. It is 30 days if you are filing it at the Board of Immigration Appeal. It is also 30 days if you are filing a motion to reconsider, which is different from motion to reopen. It is 90 days if you are filing a motion to reopen at the immigration court level. And if you are filing a motion to reopen at the immigration court level, you must have a new evidence or a form of evidence that was previously unavailable in order for the court to reopen the case. So those are the main issues with motion to reopen. And as I said before, the exceptions to the 90 days deadline and to the one-time rule is if the motion to reopen is a joint motion, if both parties, that is, ICE attorneys and the respondent, if they both agree to file the joint motion to reopen, then the time limit will not affect it. It will be an exception to the 90-day deadline. It will also be an exception to the 30-day deadline at the Board of Immigration Appeal level. So if you desire to reopen your case, file a motion to reopen, and you are out of time, if it's at the immigration court level, you are already outside the 90-day deadline, or if it's at the Board of Immigration Appeal level, if you're already outside the 30-day deadline, then your best bet is to try to contact ICE attorneys so that you can file a joint motion to reopen. A joint motion to reopen is an exception to the 90-day deadline. It is an exception at the immigration court. It is an exception to the 30 days deadline at the Board of Immigration Appeal. It is an exception to the one chance rule because you can only file a motion to reopen one time. You cannot file it 2 times. You cannot file it 3 times. You can only file it one time. So a joint motion to reopen is an exception to the one-time rule. So if you're out of time, your best bet may be to reach out and get the opposing counsel, the ICE attorneys, to agree to a joint motion to reopen. Usually, ICE attorneys will not agree to a joint motion to reopen except you provide a justifiable reason. Like I said, if there are changed circumstances, maybe at the time that the previous hearing was had, maybe there were issues that were not available at the time. Maybe there were new reliefs that came up that were not available. Let me give you an example of a situation where a motion to reopen can still be filed outside the 90 days deadline, even without the opposing counsel agreeing to it. Okay, let's say you present a case of asylum and a trial was conducted, and during the trial, After the trial, the immigration judge, denied the asylum case. And now you file an appeal. Maybe while the appeal was pending, the respondent got married to a US citizen who files a petition, I-130 petition, on his or her behalf. While the appeal is pending, if that petition was approved, if the I-130 petition was approved, then you can file a motion to reopen. In fact, if the appeal is pending, you file a motion to remand, not a motion to reopen. You file a motion to remand with the Board of Immigration Appeal, where the appeal is pending. But if there was no appeal, maybe when the immigration court issued the decision, there was no appeal of that decision, then upon the approval of the I-130, you can either approach the ICE lawyers and tell them that, look, you are out of time for a motion to reopen, but you have a new relief that was not available at the time of the previous trial. And considering the fact that you are out of time, you want them to agree to a joint motion to reopen. Or, of course, in such a situation, you will have to, in addition to the I-130 approval letter, you also have to present evidence that the respondent is prima facie eligible for adjustment of status. That is, there are no other disqualifying factors. Maybe the respondent does not have criminal issue that can come up during trial. There is no issue of a medical ground of disqualification. There are no issue of inadmissibility, maybe entry without inspection or criminal matter. So you have to show evidence that the respondent is primarily eligible for adjustment of status. So if you present all that evidence and you present it to the approval letter and you present it to the ICE lawyers, then they are likely going to agree to a joint motion to reopen. So because that is the only way that you can go out of the 90-day deadline. On the other hand, if the appeal is still pending with the Board of Immigration Appeal, you don't need a motion to reopen. What you need to file is a motion to remand. Again, you will attach the I-130 approval letter and all the evidence that the respondent is prima facie eligible for adjustment of status, proof of legal entry, proof of evidence that there is no medical ground, and evidence that there is no issue of inadmissibility. And in this case, if the appeal is still pending, I will always suggest that the respondent submit the adjustment application to USCIS, obtain a receipt notice, and then attach a copy of that application to the motion to remand with the BIA, so as to give the BIA ample reason to remand the case. If all these things are done, I will tell you that at least I'm almost 90% certain that the case will be remanded to the immigration court to enable the respondent apply for adjustment of status. So that is the way motion to reopen with the immigration court. That is the way it is. And like I said, it is different from every other motion. You can only file a motion to reopen one time. It is not something you can do two times, except you fall into one of the exceptions. There are 3 exceptions to the filing deadline. One is another in absentia. The one-time rule does not apply. 2 is a joint motion to reopen. If it's a joint motion to reopen, the one-time rule does not apply. And the third and the last one is what is called sua sponte motion. That is, if the court on its own decide to reopen the case, the one-time rule does not apply. So except you fall into one of those exceptions, you have only one time to file the motion to reopen. And this is why, excuse me, this is why it is very, very important that you don't rush into filing a motion to reopen. I mean, I've seen cases that were brought to my office where somebody will just prepare a motion to reopen and just file it, and then the judge denies it, and then they then come here. Motion to reopen, because it is only a one-time opportunity, you have to be sure that it is done correctly. You have to be sure that all the supporting evidence is there. You have to be sure that the reason, the changed circumstances that you are presenting, that opportunity was not there during the previous hearing. Because if the opportunity was there, then the judge will tell you that you had the opportunity to apply for adjustment, you didn't take it, you cannot come back and use that same thing. But it is important that you do it right in order to get your case reopened. But if you are out of the 90 days deadline, then your best bet will be to reach out to ICE lawyers to discuss the possibility of a joint motion to reopen. But again, even at that, you still have to present evidence. No lawyer is just going to agree to a joint motion. Even if you have an approved I-130 or you have any other relief, you still have to show them, you have to convince them why those reliefs were not available previously and why you did not apply at that time. Of course, usually it has to be something new, something that was not available during the previous hearing. So keep the questions coming. Keep the questions coming. I will. Okay, I think questions are coming in. Okay, first question. Do I need to do a motion to reopen if the court administratively closed my case pending the adjudication of my I-130 with USCIS? Well, no. The answer is no. Motion to reopen is not the same thing as a motion to recalendar. There are different types of motions, and this is what I've been trying to explain. There are different types of motions. You have motion to reopen. You have motion to reconsider. You have motion to remand. You have motion to recalendar. So these are different things. So if we are talking about a motion to reopen, it does not apply to a case that was administratively closed. A case that was administratively closed, that case is not over. That case has not been terminated. The decision on that case was merely suspended. The case was simply taken out of the court calendar. So that case is still pending. That respondent is still in removal proceedings. So it is not, the case is not over. So you can't file a motion to reopen for a case that is still pending. So when a case is administratively closed, what it means is that, okay, we are taking this case out of the court's calendar for now. So either party can always file a motion to recalendar. Either party can do that. And when I mean either party, the respondent can file a motion to reconsider. ICE can also file a motion to reconsider. So either party can do it. And the court on its own can also recalendar the case. So when a case is administratively closed, that case is not over. So you don't need a motion to reopen. Motion to reopen is only applicable to cases that has been concluded. A case that was administratively closed has not been concluded. So they are different things. So you do not need a motion to reopen if your case is administratively closed. So what you need to do, you wait for the I-130 to be adjudicated. So if your I-130 is approved, then you file a motion to recalendar. Your case is still pending in court. You just tell the court, okay, I'm ready to go ahead with this case. We are ready to proceed. We now have an approval and we need to proceed. So that is not a motion to reopen. That is a case of motion to recalendar. You don't need any evidence to attach to that. You can ask the court to recalendar your case with or without an approval. You don't. All you need to do is just to. If you can even write a letter. I want this case to be recalendared. That's it. That's all you need. So it is not the same thing as a motion to reopen. Next question. I was ordered removed because I had a criminal record. This record has now been pardoned. Can I now file a motion to reopen based on this? Well, it depends on a number of factors. The answer is not a straightforward yes. The answer is yes, but it's not a straightforward yes because there are issues here that has to be resolved. Number one, if you have been ordered removed, that means there is a current situation, there's a current order on you from the immigration court. The removal order was based primarily on the criminal record. You have to go back to look at the NTA. What are the allegations in the NTA? Usually, NTAs will say you are not a citizen or national of the United States. You are a citizen of XYZ country. You entered the United States either on so-so date with authorization to remain until so-so date, or if it was a case of somebody who previously had a green card, your status was adjusted to that of lawful permanent resident on so-so date. Now they will now mention the issue of the criminal allegations against you as the reason for requesting that the case be for you to be removed from the United States. So now, if that case is resolved, if you have been pardoned, yes, you can file a motion to reopen. But because your motion to reopen is probably, well, this question didn't state for how long after the removal order. It didn't say whether it was still within the 90 days. If it was within the 90 days, yes, you can file a motion to reopen. But if you file a motion to reopen and dismiss, if it was within the 90 days. If it was outside the 90 days, again, my first step will be to approach ICE to see if they will agree to a joint motion to reopen based on the fact that the conviction no longer exists. If you have been pardoned, it means the conviction no longer exists. So ordinarily, ICE should agree to such a motion to reopen. But if ICE disagree, I will go ahead and file the motion to reopen based on sua sponte and request the court to invoke its sua sponte authority to reopen the case. Because like I said, a court can reopen a case at any time, irrespective of the duration. Even though the law requires you to file a motion to reopen within 90 days, but the court can reopen the case 5 years after, 10 years after. They have that authority. So it is called sua sponte authority. So I will file the motion to reopen. If ICE disagree to join the joint motion, then I will file the motion and ask the court to invoke its sua sponte authority to reopen the case. Now, this is where you will now put up all the legal argument, because if the conviction is no longer there, it means there is no basis for you to be removed in the first place. But you need to understand that that does not take away the legal requirement that to file a motion to reopen within 90 days. So that is why I will invoke the sua sponte authority of the court to reopen the case sua sponte, so that the government or even the court cannot deny the motion on the basis that we didn't file it within 90 days that is required by the statute. So that is a clever way to avoid that, the implication of the 90-day deadline. Okay, no other questions for now. So keep the questions coming, keep the questions coming. So like I said, again, even this case, the same thing can be done if there was an appeal and maybe the appeal was still pending at the BIA level, or even if the BIA has issued a decision. You can always invoke the sua sponte authority. You can always ask the court. I take that back. You can't invoke. You can ask the court to invoke the sua sponte authority to reopen the case. So, but I will first try talking to the ICE attorneys to get them to agree to a joint motion to reopen. And like I said, if the case is, if the respondent has been pardoned, I don't see why they would disagree. But if they do, then go ahead and file a motion and ask the court to invoke its sua sponte authority to reopen the case. Okay, I think there are new questions. Okay, keep the questions coming. We are discussing motion to reopen today, and like I said, it is different from motion to reconsider. It is different from motion to remand. It is different from motion to recalendar. So these are all different types of motions. Question: is it possible for me to be removed while my motion to reopen is pending? Well, it depends on a number of factors. It depends on a number of factors. You see, I always say that immigration is not a one cap fits all. It is not, immigration is not something that the same thing is applicable to everybody. It is on a case by case basis. Usually by statute, when you file a motion to reopen in court, it serves as a motion, as a what is this word now? A kind of it put a stop to your removal. It operates as a stay of removal. Yeah, that's the word I was trying to remember. Stay of removal. So if you file a motion to reopen in court, as soon as the court stamps it, it operates as a stay of removal. So all you need to do is to ensure that a copy is served upon the opposing counsel, especially upon ICE. As I have always said, ICE is Immigration and Customs Enforcement. They are the enforcement arm of the of immigration. They don't adjudicate cases. They don't conduct interviews. Their own is to enforce court orders. Their own is to enforce court immigration law. That is their role. So if you rate as a temporary stay of removal pending the decision on your motion to reopen. So keep the questions coming, keep the questions coming, keep the questions coming. So as I said, for motion to reopen, it has to be filed within 90 days after the order, the removal order that you are trying to reopen. So you have 90 days to file a motion to reopen. This is different from motion to reconsider. In the case of a motion to reconsider, you have only 30 days. You have only 30 days. And one of the differences between motion to reopen and motion to reconsider is that for motion to reopen, you have to support it with an affidavit. You have to explain changed circumstances. You have to provide new evidence that was not available at the time, during the previous trial. You have to provide all of that in order for a motion to reopen to stand a chance of being approved. However, in the case of a motion to reconsider, You don't even need any of that, but you have only 30 days to file it. Motion to reconsider, you are saying that the court is wrong as a matter of law. So you have to cite the law that you believe that the court was erroneous, that the court erroneously interpreted. So all you need to attach to your motion to reopen is your brief. You have to attach a legal brief where you will explain why the court was wrong and why the court should reconsider their decision. So that one has to be done within 30 days, and it has to be supported by a brief, by a legal brief. On the other hand, motion to remand, if you have been ordered removed and you file an appeal and your appeal is still pending, and you want the court, the immigration court, to reconsider the case, then you can file a motion to remand. You will state the new fact or the new evidence that you want the immigration court to consider, and you present it to the Board of Immigration Appeal with a motion asking them to send it back to the immigration court so that they can look at the new, previously unavailable evidence that you are now presenting, or a changed circumstances that you are now presenting, or a new relief that you are now presenting. Now, let me explain something while waiting for for additional questions. Let me explain something right quick. When we are talking about a motion to reopen, especially a motion to reopen with the Board of Immigration Appeal, if the new relief you are presenting is, let's say an example is a case of VAWA. If you have a VAWA approval and that is something that you are presenting, the motion to reopen in this case is an exception to the 90-day deadline. One is an exception to the one-time motion to reopen rule, and is virtually an exception to all the rules that governs motion to reopen. If it is based on a VAWA that has been approved, yes, you can file a motion to reopen at any time, even outside the 90-day deadline. It can be filed. So keep the questions coming. Okay, I think we have a new question here. If a new law is passed and said law has to do with the reason that I was ordered removed, can I file a motion to reopen my case based on the new law if it is after 90 days? Well, if the law has not, if the removal order has not been implemented, yes, you may be able to file it. Again, it also depends on the it depends on the language of the law. Remember that the Congress usually does not make retroactive laws. They do not backdate laws. So, except the law specifically give room for you to be backdated, it may be a tough buy. But usually, if after the removal order you are still here, the removal order has not been implemented, the chances of your case being reopened is very, very high. Very, very high. That is what I would say. The chances is very, very high, irrespective of whether it is within the 90 days or it is outside the 90 days. The chances are very, very high for as long as you are still here in the United States. If the removal order has not been implemented, yes. But where the removal order has been implemented, it is going to be impossible, except the law was specifically backdated. If the law was specifically backdated, yes, you may be able. But if the law was not backdated, if you are already removed based on this, if you are already ordered removed and that removal order has been implemented, then any new law by the Congress may not provide an opportunity for you to come back to the US. So keep the questions coming in, keep the questions coming in, keep the questions coming in. While waiting for the questions, so let me, oh, okay, I think we have a new question. I was ordered removed and my green card was denied even though I had an approved I-130. Will filing a motion to reopen fix my status if the motion is granted? Well, this question is not very, it's not detailed enough because there are so many things that I don't understand. I mean, if you said you were ordered removed and your green card was denied, so if why was the green card denied? Was it denied by immigration because they lack jurisdiction? Because usually when somebody is in removal proceedings, immigration that is USCIS does not have jurisdiction over such a person. It is only the EOIR, that is immigration court, that can adjudicate adjustment of status. So why was the green card denied? Was it denied by USCIS because they lack jurisdiction? If yes, you can file a motion to reopen and ask the court to adjudicate your adjustment of status. That is assuming you are within the 90 days. If you are outside the 90 days, you liaise with ICE, the ICE attorneys, to see if they will agree to a joint motion to reopen based on changed circumstances. And then you may be able to reopen your case. But if it was the immigration court that denied the adjustment, that denied the green card application, then I don't see them granting a motion to reopen because, I mean, if they have previously adjudicated the adjustment application, if they have previously adjudicated the I-130, so if you refile it and ask them to reopen the case, they will not do that, except if they deny the I-485, the adjustment, and now you have an approved petition which you didn't have before, that constitutes a changed circumstances. If you are within the 90 days, you can file your motion to reopen. If you are outside the 90 days, then you have to reach out to ICE to ask them to join in a joint motion to reopen in order to have your case reopened and adjustment adjudicated. Next question. Can I apply for EAD while my motion to reopen is pending? No, this is, motion to reopen is completely different. This is not a relief. This is not a relief. And it is very important to understand what a motion to reopen is. A motion to reopen is not a relief. If you are not previously eligible for employment authorization, filing a motion to reopen is not going to make you eligible. Motion to reopen is not a relief. But if you have an adjustment application and your motion to reopen is granted, yes, after the motion has been granted, yes, you may be eligible to renew work authorization. For example, let's say you previously filed an asylum and the asylum application was adjudicated and denied. Maybe subsequently you married a US citizen who filed a petition for you, the petition was approved, now you file a motion to reopen. Now, when you file the motion to reopen, even though you have already filed an application for adjustment of status, because you have a removal order, you may not get an employment authorization. But as soon as your case is reopened, then you can apply for employment authorization based on the pending adjustment application. So, like I said, motion to reopen itself is not a relief, but when it is granted, it brings back your case to life. So, and once your case is back to life, then you can apply for employment authorization. So, keep the questions coming. Keep the questions coming. Keep the questions coming. We are discussing motion to reopen today. Motion to reopen at the Immigration Court. Motion to reopen at the Board of Immigration Appeal level. So both of them constitute EOIR, Executive Office of Immigration Review. That includes the Immigration Court and the Board of Immigration Appeals. So those are the motion to reopen we are discussing today. While waiting for your questions, let me just recap a little. We have discussed it. Motion to reopen, you can only file it within 90 days of the previous removal order at the immigration court level. You can only file it within 30 days of status. Then you must file the adjustment application and attach the application and the receipt notice to the motion to reopen so that the court can actually confirm that you have a legitimate or prima facie eligibility for the relief you are seeking. In addition, you must attach to your motion the evidence that there are no issue with your adjustment or with the relief you are seeking. There are no issue of inadmissibility. There are no issue of admission. There are no criminal issue exceptions to the one-time rule. So that is why it is important that you package your motion correctly and adequately before you file it. Okay, new questions. My case was previously with the court, but I appealed my case. Where will I file my motion to reopen, with the court or the BIA? Well, if you are ordered BIA, that is the Board of Immigration Appeal, they usually return files back to the immigration court when they are done with appeals in some cases. But because you don't have a way of knowing, what I will do, especially if time is of essence, I will first call the BIA to find out if my case file is still with them. And if you are still with them, and if you are not sure, because a motion to reopen, especially based on a relief that does not require the payment of fees. Again, this is another issue that I will discuss. Filing a motion to reopen, when to pay the fees and when not to pay the fees. So if you are filing a motion to reopen based on a relief that does not require the filing of fees, then I will file it with both if time is of essence. But it's always good to locate the file. If the BIA has the file, was at the BIA, and after the appeal was dismissed, if the BIA returned the file to the immigration court, if you file your motion with the BIA, if the BIA rejects your motion claiming that they do not have the file, if you run out of time at this time, I believe that this will be a positive thing that you will be able to use to ask the court to invoke its sua sponte authority to reopen the case and not deny it on the ground that you didn't file it within 90 days. So very important. So all these things makes a big difference. But again, if your appeal was to the BIA, that is the last call. Motion to reopen with the BIA. Next question. I was previously ordered removed but remained in the country. I have a recently approved VAWA application that I did not have previously. Does this count as changed circumstances? Not yet. It does not count yet because no court will reopen your case based on a pending application. So if you have a VAWA application pending, you have to wait until the VAWA is approved, because a pending application and an approval are not the same thing. So if all you have is a pending application, the court will not reopen the case. And because you have a one chance opportunity, you don't want to waste the one chance. Because if you file the motion and the court deny it, if your VAWA is subsequently approved, you may not be able to file a motion to reopen. So it's better to wait for the approval, even if it is outside, if it takes you outside the 90-day deadline. It is always better to wait for the approval. So you have to wait for the VAWA to be approved in order to file your motion to reopen. So that is the way motion to reopen is. So keep the questions coming in. 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 We are discussing motion to reopen today. So keep the questions coming in. So talking about motion to reopen, let me address the fee briefly. Motion to reopen, there are some situations where no fee is required. Usually, you pay a fee, you pay the filing fee when you file a motion to reopen. But there are some limited situations where fee is not required. One, if the motion is sua sponte reopened by the court, where the court invoke its sua sponte authority to reopen the case, no filing fee is required. No filing fee is required where the court invoke its sua sponte authority to reopen the case. That is one. There is no filing fee required where the government, where ICE is the one filing the motion to reopen. Where ICE is the one filing the motion to reopen, no filing fee is required. No filing fee is required. 4, where the relief that you will be seeking, the relief that you are seeking as a changed circumstances, if that relief does not require the payment of fee, no fee is required. Or where the previous relief that you are asking the court to reopen, where it does not require the payment of fees, no fee is required. Let me give you an example. If you are filing a motion to reopen based on a new application for asylum based on changed circumstances, because asylum does not require the payment of filing fees, no filing fee will be required with the motion to reopen. Secondly, if you have previously filed an application for asylum and that application has been adjudicated and you have been ordered removed, but you are filing a motion to reopen because now you have additional documents or additional evidence that you want the court to consider, then no fee is required. You are not required to pay filing fee in such a situation. So on those 4 situations, no filing fee is required when you are filing a motion to reopen. Okay, I think I have one more question. Keep the questions coming in. Keep the questions coming. Can I file a motion to reopen after I was granted voluntary departure and left the country as ordered? There are new circumstances to my case, but I already left. Well, if you already left the country, it simply means that the case is over. Your case is over. You have been the case has been concluded. There is really nothing to be done. However, however, if you are fighting because you the that's a different ball game, but you are not asking for relief. All you are saying is that the basis of your removal was wrong. For example, if the allegation in the NTA, if you have new evidence or new document to show that the NTA, the allegation in the NTA is not valid. So whether you have left or not, you can always challenge that. But if the basis of the motion to reopen is to seek for relief, maybe you are married to a US citizen, maybe you want to apply for adjustment, you cannot file a motion to reopen on that basis. That case is over. However, you still have what you can do. In such a situation, what you can do is to apply for that new relief. If, for example, you got married to a US citizen after you have been removed, then the US citizen spouse can file I-1 petition on your behalf. So when that petition is approved, then you file what is called I-212, permission to apply for re-entry after removal. So it is a form of waiver. You file it, and if the waiver is approved, then you'll be able to come back into the country. But you cannot go back to reopen a case that has been concluded. But you can apply to ask for permission to re-enter the United States after deportation or after removal. You have that relief, but you cannot go back to reopen a case that has been concluded. Once you leave the country upon the grant of voluntary departure, that case is over. So you just have to look at other ways of coming back, including filing I-212, permission to re-enter the United States after removal or after deportation, as the case may be. Okay, keep the questions coming. Is there any question, or was that the last one I answered? Can I find them? Yeah, that's the last one I answered. Okay, keep the questions coming. Keep the questions coming. So, for motion to reopen, it's a little delicate because there is only one chance. You have to make sure that you package your motion very well before you go for that one chance, because once you miss it, that's it. You don't have a second chance. You can only file a motion to reopen one time. So you have to be sure that you package it very well so that you don't miss it. And you also need to understand that motion to reopen is different from motion to reconsider. Motion to reopen, you have to attach affidavit, you have to attach new evidence, you have to attach evidence that those things you are presenting now are not available during the previous trial. And of course, you also have to attach the relief that you are seeking. So if you are applying for the case to be reopened in order to apply for adjustment, you have to attach adjustment application. So you have to attach the relief you are seeking. In the case of motion to reconsider, on the other hand, the only thing you need to attach is your legal brief, because for a motion to reconsider, you have 30 days to file it. You are saying that the judge was wrong, that you disagree with the opinion of the court, and you have to show where the judge was wrong. You have to attach a legal brief where you will cite legal authorities and case laws and all other evidence that you have to conclude that the judge was wrong. So that is the only thing you need. You don't need to attach any new evidence. You don't need to attach evidence that something was not previously available and all. You are simply saying that the court was wrong as a matter of law, and you quote the law. that the court interpreted wrongly. So that is that for motion to reconsider. And of course, motion to remand, if your case is still pending on appeal, at the time you have new evidence that you want the court to reconsider, then you file a motion to remand. You still have to attach all those things. You file your motion to remand, you attach your affidavit, you attach the new evidence, you attach evidence that at the previous trial, this new evidence were not available. You attach all those things, and then you file a motion to remand instead of motion to reopen. So upon the grant of the motion, your case will be remanded back to the immigration court, and the immigration judge will have to look at the new evidence that you are presenting. So that is it for motion to reconsider. And we also have motion to recalendar, because somebody brought that up. If you are granted administrative closure, that means that your case is actually still pending at the immigration court. So you cannot file a motion to reopen. You can only file a motion to reopen where your case has been concluded. You cannot file a motion to reopen for a pending case. If you are granted administrative closure, admin closure, it means your case is still pending. They just took it out of the calendar. They just took it out of the court record, court calendar, so that they don't schedule it for hearing. That is what admin closure means. So if you have a relief and you want to proceed, you have to file a motion to reconsider, to recalendar. You have to file a motion to recalendar. Either party can file a motion to recalendar. You can file it, ICE can file it, the court on its own can recalendar the case. So that is the case with motion to recalendar. Now let me answer more questions. How does someone contact the government attorney to ask about a joint motion to reopen? Well, you need a lawyer in order to do that. So usually lawyers have means of communication. They do have means of communicating with each other. Remember that the ICE attorneys too, they are lawyers too. So as lawyers, we have channels of communication. There are ways that we communicate. We have channels of communications. We have each other's emails, and we also every jurisdiction, every ICE jurisdiction, they have what they have is a dedicated email that lawyers use to communicate with ICE, to communicate with ICE attorneys. So these are channels of communication between lawyers. So you need a lawyer in order to do that. So lawyers will have that access or access line, that those lines of communication. So we have dedicated lines that we use as attorneys, that to exchange emails, to exchange communication. So that is what you can do. So I don't think a non-lawyer will have access to that line of communication. And even if you do, I don't think they will reply. If you send an email to that line of communication, I don't think it is meant for lawyers. So, question: is it possible to do a joint motion to reopen and dismiss at the same time? Yes, if you can do a joint motion to reopen and dismiss, yes. But it depends on what you are reopening. Because if your case went through trial and you are ordered removed, you cannot file a motion to reopen and dismiss. Usually, motion to reopen and dismiss, in fact, it is usually motion to recalendar that you can do that. Motion to recalendar, not a motion to reopen. Because when you are telling the court to reopen a case, it means that case has been concluded. So a case that has been concluded, you cannot ask them to dismiss it. But if you are granted administrative if you are granted administrative closure, or if you are granted what is called the relief of withholding of removal, then you can file a motion to reopen and dismiss. Okay, the relief of withholding of removal, that's something that I've not discussed all along. So it's a good thing that this question came up, because that is one area where you can file a motion to reopen and dismiss. Because if you are granted the relief of withholding of removal, it means that your case was already over. Your case has already been concluded. But because you are also granted a relief in the form of withholding of removal, so in such a situation, if you have a new reason, if you have a new relief or a changed circumstances, something that was previously not available, yes, you can file a motion to reopen and dismiss. The court will do that, especially if the new relief you are seeking, you want USCIS to adjudicate it instead of the immigration court holding on to it. Yes, you can file a motion to reopen and dismiss. So that, but of course, you will explain it. Motion to reopen and dismiss so that USCIS can adjudicate. Because you can't just tell the court to dismiss the case without a legitimate reason, especially a case that has been previously adjudicated and a decision has been reached. But if it's a case where you are granted withholding of removal, you can file a motion to reopen and dismiss and tell the court that the new relief you are seeking, you want USCIS to adjudicate it. Also, in the case of motion where you are granted administrative closure, admin closure, yes, you can file a motion to reopen and dismiss if you have a new relief that you want USCIS to adjudicate. So in your motion, you state that you have this new relief, but you prefer that USCIS adjudicate it. So the court should reopen and terminate it. So you can file a motion to reopen and dismiss in those situations. Next question. Is it possible to do a joint motion to reopen and dismiss at the same time? Yes, I've already answered that. Yeah, it is possible in those situations that I explained. Next question. I was ordered removed, and right after I was in hospital after a stroke. So I missed the 90-day deadline to file. Is it possible to file a motion to reopen if I explain the circumstances? Yes, if you have a new relief or a changed circumstances. But what you do in such a situation, my recommendation is to first contact ICE. Contact ICE attorneys and present the changed circumstances. Present the new relief that you now have that was previously not available. Present the reasons why you are unable to file your motion within 90 days, and present evidence that you are prima facie eligible for this relief, and then ask them to join in a joint motion to reopen. And I believe they will join it. Yeah, you can do that. You can do that. But you cannot just simply go back to court and file a motion to reopen. So you still have to show changed circumstances. You still have to show evidence that those things you didn't have the opportunity to present it before at the previous hearing. You still have to show that you have a new relief that if the case is reopened, the court will be able to adjudicate. So you have to present all of that in addition to your motion to reopen. Keep the questions coming. Keep the questions coming. Next question. Why would the government agree to join to a joint motion? How does it serve them? Well, it does not serve the government. It does not serve the government, and that is why it is not automatic. If you listen to my explanation all along, I stated clearly that you have to present a persuasive case. It is not automatic. It's not that you just ask them, oh, I want you to join in my motion to reopen, and then they will just agree. No, you have to present a persuasive case. In fact, you can present a persuasive case and they can still deny. They can still tell you, sorry, we don't want to join in your motion. So it's not automatic. It's not automatic that once you contact them, they are going to agree. No, it's not automatic. Secondly, you have to present a persuasive case. One, you have to show them why the motion is meritorious. That is, new document that you have, new evidence that you have that you want to present, new relief that you have that you want to present. You have to show them why those reliefs were not available at the time. Maybe, for example, at the time you were not married, but subsequently you got married. So you have to let them know that it was not as if you had that relief and you didn't present it. These are things that happen subsequently. So it's not automatic. You still have to persuade them, but you have to show evidence that you are also eligible for the relief that you want them to consider. So asking them to join in a motion, that is normal. I mean, just like the Bible says, ask and you shall be given. So the fact that you are asking does not mean that it's automatic. It does not mean that they are going to agree. So it does not serve them in any way. So it is not in their interest. It is in your own interest. But if you present a persuasive case, yeah, they will always join. For example, if you have been granted a withholding of removal in the past, and maybe at the time you are granted a withholding of removal, maybe you are not married. Maybe you presented an asylum case at the time and withholding. Maybe your asylum was not granted because you filed it outside the 1-year deadline. But the court believed your story and the court told you that, look, you didn't file this asylum within 1 year, therefore we cannot grant you. However, we believe you and we are granting you withholding of removal. So if you are granted withholding of removal, maybe 5 years down the lane, you got married to a U.S. citizen and your U.S. citizen spouse now filed I-130 petition on your behalf, and that petition has now been approved. So if you present a request for a joint motion to reopen to the government in this case, to ICE in this case, yes, it does not serve ICE purpose. It is not in their interest. They are not interested in you. But they also know that you have been granted withholding of removal. So they know that it's not as if you are about to be removed. So they know that now you are married and you have an approved I-130. And if you present evidence that you are eligible for adjustment, you show the I-485 that you have filed, you show them the receipt notice, you show them a copy of the adjustment application, you show them proof of your legal entry to show that you are prima facie eligible for adjustment, you show them maybe evidence that you do not have a criminal ground of inadmissibility, maybe you do FBI background check or even state background check to show that you are eligible for adjustment. You present all these things to them. Yes, they will join because it does not serve their purpose in any way to prevent you from getting your adjustment when you are clearly eligible. So they are not going to deny simply because they don't want you to adjust. No. And even if they do, go ahead and file your motion to reopen directly with the court. That will be one of the exceptions to the motion to reopen, because you were previously granted a withholding of removal, which was a form of relief. So it's not as if you were ordered removed and then and ICE was waiting for implementation of the court order. But in this case, you are granted a relief. So ICE attorney will likely join. In fact, I will tell you you stand a 95% chance of them joining in this type of scenario based on the example that I gave you. Okay, next question. Hello, sir. I was getting assistance from someone with my filings, but the person was not an attorney and they really messed up my case. I got a letter saying that my case was denied because no petition was filed. Please, sir, what does this mean? And is there anything that can be done? I'm married to a USC and I was trying to get green card. Well, this is not something that I can comment on because I don't know the details. I don't know why I mean, you got a letter that nothing was filed. Are you in removal proceedings? Are you, I mean, what is the in this type of case, I will tell you this is not a podcast issue. Maybe you need a consultation. Get in touch with an experienced immigration attorney who can look into the totality of your case and advise you appropriately, because based on this little information, I don't have enough to be able to tell you one way or the other whether this is something that you can still rectify or not. But again, we need more information in order to know. So, are you currently in removal proceedings? Have you already been ordered removed? Was it a letter from USCIS based on some filing based on your marriage? I mean, just consult with an experienced immigration attorney. If you are married to a US citizen and nothing has been filed, then how come they are sending you a letter? So I don't understand. The facts are not clear enough for me to be able to advise you. But what I will say is consult with an experienced immigration attorney. If you call our office to schedule an appointment, I will be able to ask you questions. But if you also want to go online, you can call our number right now. We have a number 817-883-4495. 817-883-4495. So if you want to call in, you can do that. I can ask you questions and then be able to answer these questions. But based on the information provided so far, it is not enough for me because there are so many things that I don't know. And to give advice based on speculation, it may turn out to be an erroneous advice. So, if you want to call in, the number is 817-883-4499. I mean, call in now and I will answer your question. It's free. You don't need to pay any fee. Just call in so that I will be able to clarify the issues and then advise you appropriately. Or if you want to send additional text to explain further, my questions are: number one, are you currently in removal proceedings? That is the first question. The second question, based on your marriage to US citizen, have you filed I-130? Have you filed I-485? And like I said, again, whether you are in removal proceedings or not, we really answer a lot of questions, especially considering the fact that we are discussing motion to reopen at the immigration court today. So I don't know whether this applies to your situation or you just send this question in without being in removal proceedings. So if you can clarify that, I'll be able to help you further. But for now, it is not the information provided is not enough for me to tell you one way or the other. But I believe if you are not already in removal proceedings, if you don't already have a removal order against you, you may still be able to fix your case. Even, okay, let's see. I think there are, okay. I was put into proceedings based on this filing. I thought the correct documents were filed, but I don't know everything that was even filed in my name. Again, this is still not an easy question for me to answer because looking at the way this question is, I don't want to make some assumptions. Are you in a legitimate marriage? Are you living with your spouse? Do you have all those things? The removal proceedings, is it still ongoing? Is it over? Have you been ordered removed, or is your case still pending? If your case is still pending, all you need to do is just to file the new I-130 if one has not previously been filed. Just fix it, do it correctly. The government attorney may object to certain things, but again, if you have an experienced immigration attorney, I believe you may still be able to get your green card if your case is still pending. But if you have been ordered removed, then it's a different ball game because the standard will be much, much higher. If you have been ordered removed, it's not going to be, you are not going to be able to file a motion to reopen based on a pending application, pending petition. So it means that a new petition will have to be filed on your behalf. That petition will have to be approved before you can even think about motion to reopen. So again, it depends on the state of your removal proceedings. But largely, based on what you have, the information you have provided, I believe that you can still salvage the situation, assuming there is no removal order. If there is an existing removal order, then that is a different ball game because to get a motion to reopen, you will need an approval. It's not going to be a pending application will not be sufficient. You will need an approval. But if it is still pending, then this can still easily be fixed. So I believe that I've answered the question, at least to the best of my ability. So if you need any other clarification, you can send additional text or call in. Okay, keep the questions coming in. Keep the questions coming in. Keep the questions coming in. Today we are discussing motion to reopen at the immigration court level, motion to reopen at the Board of Immigration Appeal, BIA level. For a motion to reopen at the immigration court, you have to file it within 90 days from the date of the removal order that you want them to reopen. For motion to reopen with the Board of Immigration Appeal, you have to file it within 30 days from the date of the last decision that you want the court to reopen. There are a few exceptions to the 90 and 30-day deadline. If you are ordered removed in absentia, that is one exception. If you are filing a joint motion to reopen, that is another exception. If the court is reopening the case on its own, sua sponte authority, that is another exception. Motion to reopen at the court can only be filed one time. So I call it one chance. So it's a one chance situation. And that is why you have to package the motion correctly before you file it. It's a one chance situation. And motion to reopen is different from motion to reconsider. For motion to reopen, you need to attach an affidavit explaining why you want the case to be reopened. You need to attach evidence that was previously not available, why you didn't present the case before, because it was based on changed circumstances. You also have to attach the relief you are seeking, the application that you want the case to the court to consider. You have to attach that application. You file it with USCIS, get the receipt notice, and attach it to the motion. In addition to that, you have to attach eligibility requirement, evidence that that application you are requesting, if the case is reopened, you are actually eligible for that application. For example, if you are asking for relief of adjustment, you have to show evidence that you are not inadmissible on criminal ground, on other grounds of inadmissibility. You have to show evidence that you have legal entry. You have to show all those things in addition to the application. So if you don't have all of them, if you file your motion and it is denied, you lose that opportunity. It's a one-time thing. And of course, motion to reopen requires the payment of fees. There are fee exceptions. If it's a sua sponte motion, there is no exception, there is no fee. If it is a motion filed by the government or ICE attorneys, there is no fee. If it's a joint motion to reopen, there is no fee. And if it's a motion that is based on a relief that does not require the payment of fees, there is no fee to be paid. So, motion to reopen is also different from motion to remand. If you are ordered removed and your case is still pending on appeal, if you have a new ground that you want the court to reconsider, you don't file a motion to reopen. You go to the Board of Immigration Appeal and you file a motion to remand. And you also attach all those prima facie eligibility requirements and then file the motion to remand with the Board of Immigration Appeal. Okay, another question. What happens once the motion to reopen has been granted? Yeah, you have the opportunity to present your relief. If, for example, you are asking the court to reopen the case to allow you to apply for adjustment, stating that the relief of adjustment of status was previously not available during the previous trial. So once the motion to reopen has been granted, then it means you have the opportunity to present your adjustment application. So in which case, if you are applying for adjustment, as soon as the case is reopened, you are now eligible to apply for employment authorization. So you can apply for work authorization while you are waiting for the court to set the case for a trial. And if the case has been set for trial, you can apply for work authorization while waiting for the court date. You can also ask the court to dismiss the case if you want USCIS to adjudicate the relief that you are seeking. For example, if your relief is based on marriage and you want USCIS to adjudicate your adjustment, you can tell the court to terminate the case so that USCIS can assume jurisdiction over your case. So now you have the opportunity to present your case either to USCIS or to immigration. Again, for as long as your case is pending in court, for as long as you are in removal proceedings, USCIS does not have jurisdiction over your adjustment application. So if you want to go back to USCIS, you will first have to ask the court to terminate the proceedings. And usually, the court will terminate it if the government is not opposed to it. If the government is opposed to it, the court will not terminate it. Next question. If my motion to reopen is denied, can I appeal that decision if I think it was in error? Sure. Every decision by the immigration court is subject to appeal. If you disagree with it, yeah, you have the right of appeal. You can appeal it. Yeah, you can appeal it. But for a motion to reopen, if the Board of Immigration Appeal denies it, you cannot appeal further because it is a discretionary relief. It is a discretionary relief. The court does not interfere where the relief you are seeking is discretionary, except you can show that the court was wrong as a matter of law. If you can show that the court was wrong as a matter of law, then you may be able to appeal it further. But if it is if it's a relief that is discretionary, the court, you cannot appeal beyond the Board of Immigration Appeal. If the immigration court denies it, you can appeal it to the Board of Immigration Appeal. And if the Board of Immigration Appeal denies it, You can only appeal it if it is a matter of law. If it is a discretionary issue, you cannot appeal it. Let me give you an example of something that is a matter of law versus something that is a matter of discretion. Um, let's say, I remember I once filed a motion to reopen on behalf of a client. This client filed an application for asylum. He was referred to the immigration court. This client was represented by a different lawyer, and then they went into trial with the asylum application. No. I take that back. The client was not represented by any lawyer. I think he went into the trial by himself. And of course, not being a lawyer, he didn't present a good case. So the asylum application was denied. After that denial, still within the 90-day period, he hired a lawyer to help him file a motion to reopen. So he paid the lawyer, but for some reason, the lawyer did not file the motion within the 90 days that is allowed by law. Now, this client filed a grievance complaint against the lawyer with the state bar. The state bar made a determination that the lawyer actually neglected the job that was given to him. And of course, they penalized him. Subsequently, the client was referred to me, and the client came to me. So I reviewed everything, then I filed the motion to reopen again. Now, it's a good thing that I'm referring to this case, because this case just reminded me of another exception to the one chance rule of a motion to reopen. I will explain it, and I will come back to the one chance rule of a motion to reopen. So this client came to me. So I reviewed the case, and I filed a motion to reopen outside the 90-day deadline. Remember, the relief in this case is asylum. This client has already presented asylum to the court, and the court has reviewed it, and the court has denied it. So it's not as if I'm presenting a new relief. However, I have documents that the client didn't present before, because the client didn't have those documents at that time. He was still waiting for this document to come at the time of the hearing. So based on this, I filed the motion to reopen, attach affidavit, present the new documentations, evidence that the previous lawyer that was supposed to file the motion to reopen did not do it. There is something called matter of Lozada. Is a case. Lawyers will understand it. It's called matter of Lozada. It is one of the exceptions to the one-time rule of a motion to reopen, where a respondent can show that the lawyer was not effective. We call it ineffective assistance of counsel, where the respondent can show that he or she received ineffective representation from his or her lawyer. Then the court will reopen the case. The court will not use whatever error, whatever mistake that the lawyer made. They will not use it against the respondent. However, this matter of Lozada, there are rules and regulations that must be complied with before the court will take it into consideration. Number one, the client, the respondent, must file a grievance against the lawyer. A copy of the grievance must be presented to the lawyer, and the lawyer given an opportunity to respond to the grievance. So in this case, in this particular case, because the state bar has already made a determination that the lawyer actually neglected the duties given to him. So it means that the court has already the disciplinary committee, legal practitioner disciplinary committee, they have actually looked into the case and concluded that it is true that this lawyer messed up. So with all this, I filed a motion to reopen, but the judge denied it. One, the judge cited the one chance rule, that the motion to reopen, we can only file it one time, and that in this case, the lawyer had previously filed one out of time, and that it doesn't matter whether we didn't attach filing fee to the motion, he was going to deny the motion. Thirdly, the judge stated that the respondent did not show proof to the court, proof to the immigration court, that the lawyer was given a copy of the complaint so as to allow the lawyer to respond and for the court to make a proper determination. So the judge denied the motion to reopen on these three grounds. Now, this is where I was distinguishing between something that is discretionary and something that is of legal issue. I filed an appeal against this motion, against the denial of this motion on legal ground. This is not a matter of discretion. On legal ground, because the judge was wrong on those three grounds. Number one, the fact that a motion to reopen has previously been filed, when a second or subsequent motion is filed based on ineffective assistance of counsel, it is one of the exceptions to the one-time rule of a motion to reopen. So I believe the judge was wrong on that ground. So I cited all the statute that stated that the ineffective assistance of counsel is an exception to it. Secondly, the judge argued that we didn't pay the filing fee for the motion to reopen and deny it on that ground. Again, that is a legal issue. That is not a discretionary issue. The judge was wrong because the law requires a filing fee only where the previous application or the main application does not, it's an exception. The payment of fee is not required where the previous application or the main application does not require the payment of fee. In this case, the previous application is an asylum application. So what we are asking the court to do is to reopen the case so that the respondent can have the opportunity to represent his asylum application. So asylum application does not require the payment of fee. Therefore, the judge was wrong by requiring the payment of fee when the law does not. So that is again a legal issue. It's not a discretionary matter. And thirdly, matter of Lozada, ineffective assistance of counsel. It is true that the case law, that matter of Lozada, one of the requirements is that the respondent must show that a copy of the grievance is served to the lawyer so that you cannot do this thing behind the lawyer. If you are making an allegation against a lawyer that the lawyer messed up, that the lawyer provided ineffective assistance, you have to provide a copy of your complaint, a copy of your grievance. You have to provide a copy to the lawyer so that the lawyer can have the opportunity to respond to your allegation. So because of that, the judge denied it, stating that we didn't show evidence that a copy of that filing was provided to the lawyer, to the previous lawyer. Now, again, I filed an appeal on that ground as well, that the lawyer is wrong, because in this case, the disciplinary committee, the state bar, has already, they have adjudicated this case, which means they have heard from both parties. They have heard from the respondent, they have heard from the lawyer. After all of that, they have come to the conclusion that the lawyer neglected the job that was given to him, and they penalized the lawyer. So all this could not have been done without the lawyer knowing about it. So it means the lawyer has been presented a copy of the grievance against him. He has been given an opportunity by the disciplinary committee to respond, and he has responded. Excuse me. So it means the lawyer has responded. So that cannot be a ground, because we are not doing something that the lawyer is not aware of. The lawyer has already been given an opportunity to defend himself before the state bar, and he has done that. So the judge cannot turn around and use that as a ground to deny. So on these three grounds, we filed an appeal, and of course, the appeal succeeded. But the reason I'm bringing that up today is to show the difference between a discretionary relief and a legal relief. So if a motion to reopen is denied by the immigration judge, the only appeal you can file is to the Board of Immigration Appeal, because a motion to reopen is a discretionary form of relief. However, where the motion is denied on a legal basis that you believe that is wrong, you can file the appeal to the BIA, and if the BIA deny it, you can file an appeal to the Federal Fifth Circuit. So you can go higher if it was denied based on error in law. So let's answer more questions. If my motion is denied, can I appeal? Okay, I believe that's the one I just answered. Is there... Okay, I will answer it. Let me quickly answer this one. Is there any way to have a motion with the court expedited? No. Excuse me. No, you cannot have a motion. The court have discretion over cases in their court, every judge. You can file a request for expedited, you can file expedited request, but ultimately it is the court that determines when to grant it and when not to grant it. So we don't have control over that. But an expedited request can be submitted to the court. But whether it will be granted or not is entirely at the discretion of the court. Now, I have another question here. Let me just read it. Hello, sir. Thank you for this session. Deportation question. A couple, husband and wife, entered the United States with B2. Then the husband applied for a change of status to F1 alone, and in the process, the wife left the country with her B2. After the change of state, what can be done, sir? Can she apply for B2 immediately or F1, or should she apply for F2, or does she have to wait for 5 years to apply? Excuse me. Although that is not what we are discussing today, but I will just quickly answer that. Every non-immigrant status is 100% discretionary. And F1, F2, those are discretionary. R1, H1B, O visa, P visa, all these are discretionary visas. Every single visa that is non-immigrant is 100% discretionary. Now, since the B2 visa has been cancelled in this case, so there is really nothing that the applicant can do. However, because the husband has been granted F1 status, she can apply for F2 status at the embassy, at the US embassy. She can apply for F2 status. But to be eligible for F2 status, she will need a new I-20. The husband will have to obtain a new I-20 for her that will indicate her F2 status. The husband will have to show evidence that he has been maintaining F1 status. That is, he has been going to school. He will probably have to attach his transcript and some other evidence to show that he has been going to school since the F1 was granted. The husband will show evidence that he has the financial capacity to take care of the family, because the F2 I-20 we have to state how much the minimum amount or the average amount that the F2 applicant will need to have in order to stay in the United States on F2 status. So she will have to present all this evidence when applying for F2 visa. Now, having said that, even if all these things are presented, it's still no guarantee that they will give her F2 visa, because, like I said, this is 100% discretionary. Every non-immigrant visa is discretionary. There is nothing that any lawyer can do. Not even the president can do anything about it. That is the way the statute was enacted. It is the Congress that gave the consular authorities the discretionary power. So there is really nothing anybody can do. Question on our topic of the day. Today we are discussing motion to reopen. Motion to reopen at the Immigration Court. Motion to reopen with EOIR. That is what we are discussing, motion to reopen. And let more questions come in. We have about 5 more minutes to go. And again, I want to apologize for my absence in the last couple of weeks. It was for a good cause. I traveled for the dedication of a resource center that we built for my alma mater. So, no, why don't you show the other? Yeah. So, that was why I was unavoidably absent the last couple of weeks. And last week I was in the plane, so I couldn't handle this in the plane, even though I could text, but I could not talk while on board. So apology for that. Next time we will make adequate arrangements before any future absence, if any. So keep the questions coming. We have a few more minutes to round up today. Keep the questions coming. Keep the questions coming. Keep the questions coming. We were discussing motion to reopen today. Motion to reopen at the Immigration Court. So for a quick recap, for a motion to reopen, it can only be filed within 90 days of the last order that we are trying to reopen. There are some exceptions to the 90-day deadline. One exception, where the government is the one filing it, there is no, the 90-day No, where there is a joint motion to reopen, where there is a joint motion to reopen, there is no 90-day rule. Where it is a sua sponte motion, that is motion by the court. If it is the court that is reopening the case on its own, there is no 90-day rule. Where the previous order is an order in absentia, there is no 90-day rule. And the last exception, which I didn't mention before until lately, which is the ineffective assistance of counsel, where the delay, where the motion is based on ineffective assistance of counsel, matter of Lozada, there is no, the 90-day deadline will be waived. Again, this does not apply to motion to reconsider. For motion to reconsider, it is only 30 days. It has to be filed within 30 days. And of course, for motion to reopen, you must attach affidavit, attach the new evidence that was previously not available, attach the application for the new relief that you are seeking, and of course, you attach the filing fee if it is required. Filing fee is not required where the government is the one filing it, where it is a joint motion to reopen, where it is a sua sponte petition, where it is based on a motion, on a previous order that was in absentia, and where it is based on a relief that does not require the payment of a fee. So filing fee is not required in those situations. So the motion to reopen is a one-chance thing. It can only be filed one time, except where the few exceptions apply. Few exceptions to a one-time filing of a motion to reopen, where it is a joint motion to reopen, where it is based on an in absentia order, where it is a sua sponte with the immigration court. No, motion to reconsider, it is a legal requirement to file a brief with a motion to reconsider. It is not a legal requirement to file a brief with a motion to reopen. But the motion to reopen must be supported by an affidavit. Affidavit is a legal requirement. It must be supported by an affidavit. Evidence of the new document, the new evidence that was previously not available, those are legal requirements. Evidence of the relief that you are seeking, those are legal requirements. But filing a brief is not a legal requirement for a motion to reopen. But it is a legal requirement for a motion to reconsider. For a motion to reconsider, a brief must be filed. For a motion to reopen, a brief is not required. So, we believe that this is where we'll be rounding up for today's episode. Again, thank you for watching. Thank you for listening. And remember to invite your family and friends. And also remember to subscribe to our channel so that you will be notified whenever we go live. So again, see you next week. This is every Wednesday, 12 p.m. Central Standard Time. That is 12 p.m. Dallas time right now. That will be 11 a.m. Eastern Time. That will be 6 p.m. Nigerian time. Thank you for watching. See you next week.
I was looking for Lawyer Asekun for help concerning my immigration status because everything was upside down. Because I couldn't believe, I was even thinking maybe I'll be sent out back to Nigeria. So on getting to know him, he explained everything to me, what I'm going to do, that he's going to do everything. So fortunately for me, everything was done from him. Dr. Olu Asekun is the best lawyer so far in Texas because I can introduce as many as whoever is having problem, especially when it comes to immigration. I'm going to introduce Lawyer Asekun because he is the best lawyer. So far, so good.
Our goal here is to make our clients happy, especially in the area of immigration, family law, and personal injury.
I was looking for Lawyer Asekun for help concerning my immigration status because everything was upside down, because I couldn't believe. I was even thinking maybe I'll be sent out back to Nigeria. So on getting to know him, he explained everything to me, what I'm going to do, that he's going to do everything. So fortunately for me, everything was done from him. Dr. Olu Asekun is the best lawyer so far in Texas because I can introduce as many as whoever is having problem, especially when it comes to immigration. I'm going to introduce Lawyer Asekun because he is the best lawyer. So far, so good.
Our goal here is to make our clients happy, especially in the area of immigration, family law, and personal injury.
I was looking